North Carolina Court of Appeals issued a decision in State v. McKinney, which is valuable as a learning tool in examining the establishment of probable cause in a search warrant sufficient to withstand a motion to suppress. In this instance, Officer Bradshaw was confronted with the problem that many of you officers are confronted with, and that is protecting a citizen informant. In this case, the office manager of the apartment complex noted that a particular apartment was the subject of a great deal of traffic, people coming for all hours of day and night, staying a short period of time and leaving. And she believed that that was associated with drug trafficking. Additionally, she actually saw a hand-over-hand drug transaction from her office location. She was even able to describe the vegetation as being green in color and believed it was marijuana. But she expressed to Officer Bradshaw her concern about her safety, that if too much was revealed about her, that she might be harmed as a result of giving this information. So Officer Bradshaw had to factor that in writing his warrant. A copy of the warrant itself is in your material. If you'll note, on 4/22 of 2012, Officer Bradshaw stated he received a citizen complaint for this particular apartment. The citizen advised that there was heavy traffic in and out of this apartment. They advised the traffic made short stays and believed it was narcotic related. They stated that they had actually seen narcotics changing hands in the parking lot with the resident of that apartment. Officer Bradshaw furthered his investigation on that same date by establishing surveillance on that apartment. As the application notes, at 12:41 hours, I observed a red Pontiac arrive at the apartment. The driver exited the vehicle and entered the apartment. At 12:47 hours, the driver returned to the vehicle and left the area. A traffic stop was conducted on the vehicle for a violation of Chapter 20 law, and during the investigation, the driver was arrested for marijuana. He was also in possession of $4,258 in U.S. currency. The driver had a history of narcotic arrest. The marijuana was found in a large bag and was almost empty. In this case, which was decided before Riley, the officer conducted a search of the arrestee's cell phone. The arrestee, Mr. Fauché, had this text message from a Chad. "Brah, when you come to get money, can you bring me a fat 25? I got the bread." That was at 12:12 p.m. "Can you bring me one more, brah?" Me, about 45. Chad, aight. Through his training and experience, Officer Bradshaw stated that he believed that Mr. Fauché delivered marijuana to the residents at the subject premises. Furthermore, based upon the facts described above and his training and experience, Officer Bradshaw believed that there was probable cause that items to be seized, particularly controlled substances in violation of General Statutes 90-95, and other items listed herein are in the premises to be searched as described herein. Officer Bradshaw also noted through his training and experience that he found it to be indicative of persons involved in narcotics and the dealing of narcotics to only transport the amount of narcotics expected to be dealt at any given location and to store the bulk of the remainder of their narcotics at their residence, which these persons use as stash houses to conceal their narcotics. These persons also conceal records of drug transactions and large amounts of currency at their residence or in their vehicles. The court then issued its decision. The inference the state seeks to draw from the contents of this affidavit that the narcotic drugs are illegally possessed on the described premises does not reasonably arise from the facts alleged. Thus, the search warrant used to search defendant's apartment was defective because it was not supported by probable cause. The court also stated the evidence included in Officer Bradshaw's search warrant application clearly establishes probable cause that Fauché had been involved in a recent drug transaction. However, the determinative question in this case is whether the application provided a substantial basis to allow the magistrate to conclude that there was probable cause of illegal drugs at defendant's apartment. Court stated probable cause requires a showing that, quote, "it is more probable than not that drugs or other contraband will be found at a specifically described location," end quote. The court noted that Officer Bradshaw's affidavit implicates defendant's premises solely as a conclusion of the affiant. Neither Officer Bradshaw nor the anonymous citizen ever witnessed any narcotics in or about the apartment. While Officer Bradshaw specifically saw Forche enter and exit the apartment prior to his arrest, there's nothing in his affidavit which suggests that he saw Forche carry marijuana or anything else inside, or that he brought anything back out upon his exit, despite Officer Bradshaw's conclusion that Forche was making a delivery at the time. Moreover, the court noted, while the text messages recovered from Forche's phone suggest that he recently engaged in a narcotics transaction with an individual named Chad, Chad is never identified or connected with defendant's apartment in any way. Court stated the inference the state seeks to draw from the contents of this affidavit that the narcotic drugs are illegally possessed on the described premises does not reasonably arise from the facts alleged. Now, the test the court is to use is to look at the facts in the context of the totality of the circumstances. Furthermore, a magistrate is entitled to draw a reasonable inference from the material supplied to him by an application for the warrant. In other words, from the totality of the circumstances, was there a substantial basis for the magistrate to infer that the items to be searched for are at that location? Our statutes in North Carolina require that a search warrant application contains probable cause showing that the items will be found in the place described and the factual allegations supporting the probable cause. It requires statements that are supported by affidavits, particularly setting forth facts and circumstances establishing probable cause to believe the items are in the place or in possession of the individuals to be searched. It is important that the officer establish what is called a nexus, what I like to call connecting the dots. We have the crime, we have the evidence to be collected, and we have the location. All of which is established by probable cause, connecting the dots. In short, it is important that we don't rely on inferences to be made by the magistrate reviewed by an appellate court, but rather take the magistrate or the judge by the hand and tell them the facts and the significance of the facts and how those facts all link together to form probable cause. So how is it we connect the dots? Well, it's important in your search warrant you state what the facts are, what do the facts mean, and how are the facts significant. For instance, foot traffic. What does it mean? Well, generally, it means surveillance of premises described herein has shown heavy foot traffic of people arriving on foot and in automobiles at various hours of day and night, staying for short periods of time and then leaving. Several of these individuals, depending upon the facts, of course, have been arrested for, are associated with, intelligence reports indicated they are involved in illegal drug activity. This heavy foot traffic is an indication of the sale of illegal drugs from said premises. As noted earlier, Officer Bradshaw was confronted with the problem of trying to conceal the identity of the office manager. Well, what if he hadn't had to deal with that? How could we apply this concept of foot traffic in the McKinney case? What might that warrant look like? A citizen has advised that he or she is located across from the subject apartment and has personally observed heavy foot traffic of people arriving on foot, staying for short periods of time and then leaving. This activity has taken place at all hours of the day and night for over 1 month. I was further advised that the last such activity was yesterday. From my training and experience, these facts indicate the sale of drugs from the subject premises. So what we're doing here is describing what foot traffic means. We describe the scope of it. Also described is when the last foot traffic was observed, so our information is timely. We then tie it to the training and experience of the affiant, indicating what these facts mean. As often happens, in this case, information was received from a private citizen. Now, in dealing with information from a citizen or from an informant, certain questions need to be answered. When did the citizen see the drugs changing hands? How many times? Why did the citizen think it was drugs? Where was the citizen located to see the hand over hand? Basis of recognizing the resident. In applying these principles to the information that was furnished by the citizen in McKinney, it might look like this. A citizen informed me on this date, from a distance of approximately 20 yards, she observed a male subject approach a car with its engine running, reached through the open car window and handed the driver a clear plastic bag of green leafy vegetation, which the citizens believed was marijuana. Now, in this situation, we are again adding credibility to what the citizen is stating that she saw, describing the actual activity. She goes on then, the affiant states, to see that the driver handed the subject what appeared to be folded currency. The male subject then looked around and hurriedly walked back to the subject premises. The affiant further states she can recognize marijuana from her exposure to it from her college days, answering the question why she believed the green vegetation was marijuana. The affiant further stated that she knows the male subject lives at the subject premises from her knowledge of the apartment complex records. If you'll notice from the search warrant in your material, you'll see that Officer Bradshaw also sought to seize drug records that he states there's probable cause to believe would be present at the subject premises. Let's apply what we know to the facts of the case. In particular, I know that whereas here an individual is demonstrated to be trafficking in drugs, it is common for there to be evidence of their drug trafficking activities such as drug records, telephone numbers or suppliers and customers, drug trafficking paraphernalia, drug proceeds, and or evidence of transfer, expenditures, or investment of drug proceeds kept at the trafficker's residence. In my experience, it's common for those involved in the illegal trafficking/furnishing of scheduled drugs to possess and keep with them, near them, and or at their residences, sums of money either as a result of scheduled drug sales or for the purpose of purchasing scheduled drugs or facilitating scheduled drug sales with others. Because such monies are not usually safely disposed of legitimately, that is, deposited in bank or declared as taxable income, it is common for those who traffic or furnish illegal scheduled drugs to keep those sums on their person or near them in a safe location, frequently in their residences and or at near their residences, and or near the same location where they keep their drugs or maintain drug operations. Citizen informants are viewed as any other informants. It's important to establish their credibility. There are certain factors that the court looks at. Have they given reliable information in the past? In this case, we know that this citizen has in fact given information to this officer in the past about occupants of that apartment complex that have led to arrests and convictions. Corroboration. In this case, Officer Bradshaw corroborated the foot traffic in that while conducting surveillance, Mr. Fauché came, stayed just 6 minutes, and left. The details. Did the informant give great detail about what they observed? Or did the informant make a statement against penal interest? Typically, that is where your informant has made buys from the particular subject if it's a drug case. It's important to establish the basis of knowledge. How did the informant get the information? Was he inside the suspect's residence? Did the suspect tell him? Did he see the suspect with the item? Did he just hear it in the street? Of course, in our case, our citizen informant actually saw the suspect engage in a hand-over-hand transaction. When did the informant get the information? And again, in the previous slides, we've shown you that the information was obtained by the informant recently in conjunction with the application for the search warrant. When did the officer receive the information? Again, that was addressed in the warrant. It is important that this language be used in dealing with informants if in fact it is true. I have received information from an informant who I know to be reliable because he has given me information in the past that has led to numerous arrests and convictions for drug-related crimes. As we will learn in addressing another case, it's not enough to just say your informant is reliable. you must go on to say that they have provided information leading to arrests and convictions. Now, in applying this criteria to the facts in McKinney, again, the citizen has provided this affiant with information in the past which has proven to be credible, leading to numerous arrests and convictions. Once again, it's important to tell the court the significance of the key facts. Officers should not leave the deduction or inference as to whether evidence could be found in a suspect's home up in the air for a judge or a magistrate to miss, no matter how obvious that deduction seems. Officers should put in the affidavit the types of evidence that, based on the officer's training and experience, they reasonably believe will be found in the defendant's home and why they believe the evidence will be there. Let's go back to the application Officer Bradshaw submitted to the court. You will note that he searched the driver's cell phone incident to arrest. Now, let's be cautious here. This is before Riley and before Worry. So again, let's assume that it was with consent in this case. In looking at the contents of the cell phone, Officer Bradshaw viewed text messages. Most of the messages were related to the sale of narcotics. The last message was sent before the traffic stop was from Chad at this number. Chad, brah, when you come to get the money, can you bring a fat 25? I got the bread, 12 p.m. Can you bring me one more, brah? Me, about 45, Chad? All right. Now, as applied to McKinney, again, in stating the significance of this time frame, the text messages indicate that Fauché was picking up money derived from sales of marijuana that he had supplied the resident of the subject premises. A fat 25 means a full quarter of an ounce of pot, meaning one weighing a full 7 grams and not one that was light in weight, indicating that the resident is seeking this for his own use. The text message further indicates at 12 p.m. Fauché would arrive at Chad's in about 45 minutes. At 12:41, Fauché arrived at the apartment complex within the 45-minute estimate. He arrived back at his vehicle at 12:47. Based upon my training and experience, an affiant might state, this 6-minute interval represents the approximate time it would take for Fauché to pick up his money, count it, drop the fat 25, and leave. Now, let's tie this all together. Let's not leave any inferences for the court. Let's take the judge by the hand or the magistrate by the hand and show them the significance. Given the heavy traffic and drug deal witnessed by the citizen informant, the text messages from and to Chad, Fauché's time of arrival at the subject premises, the length of his stay, and the large amount of cash found on Fauché's person, this affiant's observations, training, and experience establishes that it is more likely than not that drugs were delivered to the subject premises. Again, when we take the court by the hand and connect the dots, telling the court, these are the facts, these are what the facts mean in the context of this investigation, we no longer rely on the court or a magistrate to make an inference. Now, that's not to say they're going to agree with us. But if those facts are stated in that manner, it makes it more difficult for a court not to be convinced that there is not probable cause to issue the warrant.